to all of the complications that we have to deal with in thinking about distributing our products around the world and also dealing with authors around the world. I wanted to focus the concluding presentation here a little bit on trying to give some advice or give some pointers about how to try to manage the complexities here and to make it a bit simpler if we can. So these are the kind of key points that I wanted to address. We heard a lot about the differences in law from Maria's presentation between copyright and what I refer to as author rights regimes. I'm going to try to talk a little bit about what the implications of those differences might be, both on the inflow of rights and also the downstream, and talk about those practical issues there. Need to address a little bit the governing law question, which was also raised and discussed by both Maria and Louis, and then to talk about those practical issues on both sides. So that's what we'll try to talk about. First point, in terms of the key issues in dealing with legal differences that we heard about, it seems to me that there are two sides to it. So there's the question about the transfer of rights coming in from authors, so the inflow of rights, if you will. And then the question about the downstream licensing, which really has to do with customer licenses and the interplay of traditional copyright exceptions and limitations on customer licenses. Probably that's a question of expectations. So with respect to copyright regimes clearly permit the transfer of rights from authors, and outright ownership has important and useful benefits in managing rights. And as we heard from Maria, through the free trade agreements, there's an even stronger emphasis in some cases on the requirements under those provisions to recognize the transfer of rights and the freedom of contract. However, traditionally, authors' rights countries do not permit the outright transfer of copyright, but they do generally permit the transfer of some type of commercial distribution or repurposing right. Repurposing is my phrase for just a lot of adaptation, translation, derivative works, that kind of thing. In the proposed revisions to the Chinese copyright law, this is referred to as the difference between sort of private rights and property rights. So it's a bit like the commercial exploitation that Maria mentioned. So those are the issues that we're going to talk about with respect to the inflow of rights. With respect to the downstream licensing, I think it's very clear that, particularly coming from a customer's experience and knowledge of existing copyright laws in their regime, in their country, they have a very strong feeling and demand often that there's some recognition of how those exceptions and limitations should apply when it comes to reading, reviewing, sharing, repurposing content that they're purchasing. And obviously, a lot of times, the arguments that you get into are done by analogy from the kind of print environment. And that's not always terribly helpful. But these are the kinds of issues that customers will often talk about and want you to specifically address. On the other side, from the publisher perspective, my sense is that what publishers really want is certainty and clarity, and perhaps the laws of their own country should be the laws that apply, should be the governing laws that apply for these kinds of contracts. So those are the key issues, it seems to me, that come out of these differences between copyright and authors' rights issues. In terms of the governing law issues, contractual parties generally are free to choose which laws of which country should govern the contract, generally speaking. It was mentioned that there are very particular provisions. I note here the provisions under French copyright law, which basically they say an author's contract isn't really completely effective unless you include this provision. And France is certainly not alone, although, as Maria mentions, France does have a very strong tradition and practice of authority and kind of moral rights and the protection of creators. And the absence of those very specific contractual terms may have some implication with respect to the scope of rights that may be granted. For example, under French copyright law, that may reduce the exclusive transfer or the exclusive commercial rights to some type of non-exclusive first publication rights instead. So there are those kinds of issues. Now, absent an explicit governing law clause in your contracts, and there are debates that you probably should have with counsel about when it's appropriate to include those clauses and when it isn't. Some might say you should always include it, but there may be circumstances in which you don't. So if you don't have explicit language, there's generally a series of tests that a court would look to as to which laws of which countries should govern. Obviously, one important thing is the location of parties. But perhaps more important is this question about the location of the performance of the contract. And believe me, advocates and lawyers argue these things both ways. So I would argue, as a producer of a database that is largely hosted in the U.S., that people accessing that U.S.-based database are actually the performance of that contract, us providing access to that content, is taking place in the U.S., therefore U.S. governing law should apply. However, arguments can be made the other way, that the important thing is where the user is accessing, that that's actually where the contract is being performed. Basically, you can tell that there's lots of room for interpretation, which is always the case, of course, and therefore that might suggest that it's really important to think about the governing law issue. So back to managing the inflow of rights. So we talked about the fact that it might very well be a very good idea to incorporate explicit governing law clauses of the appropriate country into an author-publisher agreement. And to make sure that you're doing that of the appropriate country. So clearly a U.S.-based publisher might not wish to introduce the laws of a country other than the U.S., for example. But if there are concerns that an author would object, or that a local court, in the case of some type of dispute in the author's jurisdiction, may find the governing law clause inappropriate, then you might want to think about some other alternatives here. The alternative that I think many of us struggle to come up with is to draft agreements that sort of blend a lot of concepts together. So that it gives you the ability to argue that, well, yes, there was some discussion about the transfer of rights, and yes, we do have copyright ownership, we would assert, but there's also some discussion about the transfer of a kind of a litany, a recitation of certain types of commercial or distribution rights. Now, your theory in doing that is that if the court were to strike out somehow the copyright transfer section, they might recognize the exclusive rights to distribute and repurpose, and you might get by with that. So you often will see language, to the maximum extent legally permissible, that kind of phrasing in these agreements. Another possibility, I think, is to consider some localizing adaptations of core publishing agreements. For example, you might note in your publishing agreement that authors of certain countries, there might be additional terms and conditions that apply to them. Provide a link to your publisher website and have specific provisions that might, for example, for French authors, incorporate that horrible little clause that is necessary. So that's another possibility that you might want to think about. Then you get into interesting questions about integration of contracts and contractual language, but hey, you have to do as much as you can and be as practical as you can. So on the downstream side, one thing I want to say on the inflow side, I think that the likelihood that a non-U.S. author would object to the U.S. being the governing law for a U.S.-based publisher is fairly modest, is fairly minimal. I think that an author would understand that in submitting, whether it's an article or a book chapter or whatever it is, to a U.S.-based publisher, that the U.S.-based publisher would have a reasonable expectation that U.S. law would apply. So my sense is that may be less controversial than in the case of the downstream instance. So the case of the French university, the German institution, the institution in China, accepting that For a U.S.-based publisher, for example, U.S. governing law, U.S. law would be the governing law, might be a more difficult discussion. I mentioned here at the very bottom the question about procurement processes. Many of the customers that we deal with in the scholarly world are state institutions of one kind or another. And many of those state institutions have obligations to manage their processes through formal procurement departments. Sometimes those are at a government level, sometimes they're at an institutional level. These are the same people, of course, on the procurement side that buy pencils and pens and arrange for janitorial services and also buy access to scholarly content. So they don't tend to be, shall we say, the most sophisticated or the most flexible people in the world. So this can be an issue. And obviously, those folks will very strongly insist on their local laws as the governing law under those contracts. So, I think we often get into discussions about governing law in dealing with downstream licensing as we're managing our contracts internationally. And the arguments about copyright law and the crafting of the license language that we get into are some very basic questions. What usage rights are expected? Obviously, you want to be able to read, you want to print, you want to download things. What about repurposing? As a customer, what rights do you have with respect to extracting? Of course, the hot topic of the day, data and text mining. What about sharing? Sharing with whom? Sharing within the institution, outside of the institutions? Are there going to be limits on the ability to share content in this way? Often there's a question about reliance on copyright law. Now, lots of countries have implemented treaty language with respect to digital copyright law, but not all have. And even in those countries which have done digital copyright provisions, there are often a lot of things which have not really been fully worked through yet. For example, in the U.S., there's lots of issues about exactly the scope of exceptions and limitations in the digital environment. And I applaud the Copyright Office in really setting out an ambitious goal to try to address many of those more directly, because I think that's really required. I think often we get into arguments when customers want to rely on things like fair use or fair dealing or private copying exceptions or other references to the traditional exceptions and limitations in the analog environment, and they want to incorporate those references directly into their licenses. That sounds in some respects like a logical thing and not unreasonable. Again, it has to do with tradition, it has to do with expectation. On the other hand, as we know very well from actually some recent decisions in the U.S., that fair use is, it's not very clear, it's not very certain. So if you say that nothing in the contract somehow would go against fair use, what exactly does that mean? And perhaps everyone has a wonderful meeting of the minds. The publisher knows what the customer thinks and it's all clear. My guess is often it leads to greater arguments at some point down the line. So my sense of this is it's better to be clear. It's better to actually draft licensing language that says very specifically and very precisely what uses are permitted, what uses are prohibited, and what uses might be permitted under some conditions and with perhaps some additional commercial terms and conditions. So, conclusions. As you can tell from all of the issues that we've talked about in all three presentations, managing rights on a global basis means a lot of conscious thought and conscious deliberation. You really do have to think about questions about governing law, the question about how to approach the wide variety of methods by which rights are transferred across the world. You want to think about clarity on usage rights. Ultimately, as in most things involving business or publishing and law, it is about risk assessment. One part, I think, of the very conscious deliberation that you need to do is you need to think about, if you accept certain risks, which risks are more likely. So, yes, perhaps you didn't get that clause for the French author into your author contract. So what's the likely outcome? Is that author going to object? What's the likelihood that if they do object, it will result in significant monetary damages, or are there other remedies that you can pursue? So I think it's that kind of risk assessment, which many of us do for a variety of topics. How likely is the risk and how significant is the risk? And can you figure out ways to remedy any allegation or claim that there's something improper or inconsistent about what you're doing with managing rights? That would be something that you could reasonably do. For example, to take down some offending article, if it comes to that, out of your big database. So, prepare your best argument, have a backup plan, do some risk assessment, and think about things in a very conscious and deliberate way. Thank you.